Hello and welcome to this video on robbery. So this is on paper 1 on the AQA specification. Now the aim of this session then, or aim of this video, is to develop our knowledge and understanding of the offence of robbery by recapping the law of theft, examining together the Actus Reus of robbery, investigating the mens rea of the offence, analysing these elements through case studies, and then solving the problem question. Now the definition of robbery is contained in section 8 of the Theft Act of 1968. Now it is a person is guilty of robbery if he steals, and immediately before or during or at the time of doing so, and in order to do so, he uses force on any person or seeks to put them in fear of being then and there subjected to force. So there's quite a lot to unpick there, and that's what we're going to do in this video. So robbery is essentially an aggravated form of theft. To categorise into Actus Reus and mens rea for a visual reference there, the Actus Reus is essentially Actus Reus of theft plus force or putting or seeking to put any person in fear of force. So some knowledge will be required there of the likes of assault and battery to help you here. And mens rea is the mens rea of theft plus an intention to use force to steal. So we're going to focus on the Actus Reus elements there. So in order to have the Actus Reus of robbery, as we already described, we need a theft, a completed theft. We then need either force or threat of force. Now this force or threat of force must be used immediately before or at the time of stealing. We're going to look at this concept as well and how that can be extended. The force can be used on any person, and we're going to look at cases there where perhaps even indirect application might be enough. And finally, the force must be used in order to steal, so that's a link between the force and the theft. So we're going to deal with the first element then, the completed theft. A theft, we need to satisfy all the Actus Reus elements of theft. So for example, Section 3 appropriates. We use the same tests as we do in theft, so assuming any of the rights of the owner. Property, and you would need to identify what type of property it is. And finally, how and which way it belongs to another. So once all of them have been satisfied, now note you won't need to go in as much depth as if it was a standalone theft question, but one sentence for each one would be relevant and appropriate. Some examples then where a completed theft has happened within robbery or not. So we look at Robinson. Now the defendant ran a clothing club and was owed money by the victim's wife. The defendant threatened the victim with a knife, and during the resulting fight a £5 note fell from the victim's pocket, which the defendant appropriated. He still claimed he was owed £2 as well. Now the Court of Appeal quashed his conviction for robbery on the grounds that completed theft hadn't taken place. He genuinely believed he had the money, which is outlined as an exception to the dishonesty concept in section 2(1)(a) of the Theft Act, i.e. belief that he was entitled to the money. Now he could of course have been charged with other crimes, so ABH, but not robbery. And so it's about getting the charge right from a prosecution perspective, but in this case it was not robbery because there was no completed theft. In Corcoran and Anderton, two defendants tried to take a woman's handbag by force. Now they managed to grab hold of the bag, but the woman screamed and the two defendants ran off without it. Now the Court of Appeal was asked to decide whether the tugging at the handbag, accompanied by force, amounted to robbery, notwithstanding the fact that the co-accused didn't have sole control of the bag at any time. Now they held the offence was complete when the handbag was snatched, and appropriation didn't require either the defendant to have sole control of the bag. So if they've appropriated it, they've assumed any of the rights of the owner, and that was enough in this case. Zerai is another case which illustrates this point. So we have, in this case, a defendant and another man approached the victim, who they knew, and told him they were going to take his car. Now the defendant pulled a knife, punched the victim, and took his car keys. They then drove the car off. Now they left the car undamaged about a kilometre away. Now in this case it was found on appeal that the trial judge misdirected the jury on intention to permanently deprive. They argued there was no intention to permanently deprive here. the trial judge suggested a forcible taking of the car was enough. That's not correct. They need to intend to permanently deprive, and it was in this case they could not prove there was any intention to permanently deprive satisfactorily, and on appeal the court felt this wasn't the case. In Waters, the defendant snatched the victim's phone from her and told her she could have it back if one of her friends would speak to him. Now the police were immediately called and the defendant was charged with robbery, and the Court of Appeal quashed the conviction again as there was no intention to permanently deprive. He was always going to hand the phone back and therefore did not satisfy this element. So that outlines then the completed theft and cases where a completed theft was not appropriate or not complete, and therefore was no robbery either. We now need to look at force. Now, as mentioned, this can be force or threat of force or seeking to put somebody in fear of violence. Essentially, assault or battery is enough. So there's actually very little force required for robbery. It can be misleading given that it's aggravated theft, but very little force is actually required, but that is consistent with the likes of battery. Now it can be putting the victim in fear or seeking to put the victim in fear. So what that tells us then is force is an obvious one. If force is applied, usually it's okay to identify and easy to identify. If the victim's in fear, if they're scared, again that can usually be identified. But actually that third element, seeking to put the victim in fear, is a little more complex. So we have the idea of even if the victim isn't scared, it can still be robbery, so long as the defendant tried to put the victim in fear of harm. So it's not defined by statute, and so it's left for the jury to decide. So we're going to look again at some cases, starting with the case of Dawson and James. Now, Dawson and his fellow defendant James were convicted of robbery. They'd been nudging or jostling the victim to make it easier for him to lose his balance, and therefore a third man to come and take his wallet. The appeal against conviction was dismissed, and for the idea force is a word that's easily understood by juries, so the trial judge had been correct to leave the meaning of this to their common sense. So there was no definition of force. That was the basis of the appeal, but in this particular case they found that allowing the jury to consider what force is was sufficient. The amount of force here was quite small, but it's up to the jury to decide whether it's enough to constitute robbery, and the original case here they did and found that it was appropriate. In Clouden, the defendant's conviction for robbery was upheld when he used both hands to reach a shopping bag from the victim and ran off with it. Now the Court of Appeal held the trial judge was right to leave the question of whether the force was on a person to the jury. Now it can be argued that using a force on the bag was effectively using force on the victim. Now just a note, this is indirect. If it was battery, again following that principle, indirect battery could take place. Kind of the same idea here. You can apply force onto a person indirectly. So it wouldn't be force, however, if a thief snatched a bag which was resting on the lap of someone, so they weren't holding it. But if there's any sort of resistance, then it's easy enough to identify. However, there is a distinction between the victim who resisted it. The distinction between the victim who resisted having his property taken, for example snatching, compared to just lifting, used to be important, but now it doesn't. It's up to the jury to decide the type of force and whether it is enough for robbery. In RP and others, so the defendant here snatched a cigarette out of the victim's hand. There was no direct physical contact between them, and the jury in this case felt that that was not enough force to satisfy the element, so they were guilty of theft of the cigarette but not of robbery. And in BNR and DPP, this illustrates the idea that if you seek to put somebody in fear of force, that can be enough for robbery. So here 5 boys stopped the victim, asked him if he had a mobile phone or money and what school he went to. The victim said he had no phone or money, but 5 or 6 other boys surrounded the victim and snatched his drink and a packet of crisps from his hands. They also took a wallet from inside his pocket and took his watch and travel card. Now in this case the boy said he didn't feel threatened or scared and he wasn't physically assaulted, but the boys were still convicted of robbery. The threatening behaviour of surrounding the victim was enough to put the victim in fear, to put the victim in fear of force, and that again was enough. So we looked at force and the idea of it can be force, threat of force, or indeed seeking to put the victim in fear of harm. But it needs to be done immediately before or at the time of stealing. Now, and a good example of this would be if a gang could go to a manager's house and steal keys from into a storeroom where expensive equipment is contained, and then drive to the store to complete a theft. This is probably immediate enough. But if they left it a little longer, so they waited a day before breaking into the storeroom, this delay would probably be too long. Now, judges need to determine this issue, but there have been no decided cases really on this matter, so it's about making sure you use your judgment in a particular question. Now, also the definition here seems to imply that force needs to be used at the time of stealing, but two cases have illustrated the idea of concept of an ongoing act or continuing act for theft. So we're going to discuss those now. In Hale, two defendants broke into a house. While the first defendant went upstairs and stole a jewellery box, the second defendant stayed downstairs and tied up the owner of the house. Now, it was impossible to say whether these activities took place or precisely at the same time, or whether the jewellery box was taken after the force was applied. Now, they appealed against the conviction for robbery, arguing the theft was already complete and over when the force took place, so they argued there was theft and there might have been assault and battery, but no robbery. Now, the reason why I do that is because the maximum sentence for theft is 7 years, the maximum for ABH, for example, would be 5 years, so therefore they would get less time in prison. That might be a reason they would wish to appeal. But the court refused here to accept this argument. They claimed the act of appropriation doesn't suddenly cease or stop, but it is a continuous act, and it's a matter for the jury to decide whether or not the act of appropriation had finished, or on the facts to conclude that it was continued while the victim was tied up. So this might be easy to spot in a scenario. For example, the defendant would want to escape somewhere. Examiners like to put that, so in a shop, for example, escaping to complete the theft, to take the thing off the premises. And indeed, that was similar then to Lockley. Okay, Lockley followed the precedent set in Hale. In this case, the appellant and two others took cans of beer from an off-licence, and when a shopkeeper approached, they used violence to escape. Now, they appealed on the ground that following Gomez, appropriation was complete before the use of violence, i.e. they'd already taken the beer. Now, the court confirmed Hale was good law, i.e. a continuing act is a consideration. So if you've not quite escaped the premises, you're still in the process of committing the theft. The act doesn't suddenly stop because you've got the thing in your hands. Okay, so now we're going to focus on whether force can be on any person. The idea it can be on any person, but in addition, it can be applied indirectly. So the theft doesn't have to then happen from the person being actually threatened. We know already it can be done through a variety of different ways, but an example here would be in an armed bank robbery. A random customer in the bank that being held up would be in fear of force being used against them, but the money stolen would be the bank's property. They don't have to match and absolutely can be any person. Indeed, this concept can stretch a little further. So Clouden we've already looked at in illustrating the different elements, but the defendant approached the victim from behind, wrenched the shopping bag using two hands from their hands, and it was left to the jury to decide whether the force applied to the bag amounted to force on the defendant. If it interfered with the body, which is an indirect application of force, then it was. And the final element of the Actus Reus then is that the force must be used in order to steal. So remember, force, threat of force, or seeking to put victim in fear of force must be used in order to steal. So the force then must be used in order to carry out the theft. For example, two people have a fight where the defendant punches the victim. If he then proceeds to steal his wallet and phone, which have landed on the floor during the fight, this would not be a robbery, as the force wasn't used to steal. It would potentially be two separate offences of theft and a non-fatal offence, depending on the level of harm. So an example in a real case is James. So in James in 1997, the defendant assaulted a taxi driver, so he got him in a headlock, while another man continued to punch him. Now the other man took £200 for the taxi, opportunistically, so didn't plan to take it, but when hitting the victim, just took the money. Now the force wasn't used to steal, it was a separate offence of theft, not robbery. So we've completed now the Actus Reus of robbery. We're now going to look at the mens rea. So there are two facets to this, but which then we need to delve deeper a little bit into. The first is that we need a mens rea of theft, remembering we need a completed element of theft. So early on when we looked at the case of Robinson, for example, we looked at where there was no completed theft because of lack of dishonesty. So we're going to delve deeper into the mens rea of theft, so remembering that it's dishonesty and intention to permanently deprive. But an addition is that we need to intend to use force to steal. So we're going to focus on the mens rea of theft first. So again, we just need to look at dishonesty and intention to permanently deprive. With dishonesty, the same exceptions apply from section 2 of the Theft Act, namely section 2.1a, 2.1b, 2.1c. So looking at the rules surrounding them. Remember, we don't need to go in as much detail as we would for a problem question on solely theft, but the Goss test, as modified by Barton and Booth, must still be used to establish dishonesty, i.e., would a reasonable and honest person have done the same thing as the defendant, or would they think it's dishonest? Section 6 needs to be proven, the intention to permanently deprive. We've looked at cases already in this video where there was no intention to permanently deprive, yet, and so sorry, there was no completed theft. So illustration, again, we looked at Robinson earlier on. The £5 note which was stolen by the defendant was not theft and therefore not robbery, because they had a genuine belief they had a right to the money under 2.1a, the Theft Act. In terms of intention to use force to steal, this is the new element which is solely focused for robbery. So we have the mens rea of theft and we need the intention to use force to steal. So what this means is we need a direct or oblique intention to use force to steal. Now, direct is, it must be the main aim, objective or desire, and that test from Mohan still applies. Or it could be oblique, so it was virtually certain that you're using intention to use force to steal. Now, this could get a bit complicated when you're trying to understand the mindset for a person to use force to steal. But if you know the test well enough, the Nedrick test, then remember to delve back into your notes on that and check that the two tests. So by that, of course, we mean that a virtual certainty that intention was going to be, force was going to be used to steal, and the defendant knew that force was going to be used to steal. Now Raphael and others were convicted of a conspiracy to rob the victim by forcibly taking his car and then offering him the opportunity to buy it back from them. The question arose whether this could amount to robbery, or whether, since the victim was get his property back, albeit by having to pay for it, there was no intention to permanently deprive and hence no theft, therefore no robbery. Now, the judge in this case suggested that it was hard to find a better example of such an intention than the facts of this case. Now, they did encourage a wide interpretation of Section 6 of the Theft Act. Note, it does contrast with other cases we've discussed where the car was abandoned, for example, but this, they wanted something in return, and that is the crucial difference here. Now, if convicted of robbery then, it is an indictable offence with a maximum of life imprisonment. So of course, the cases which are going to get a higher prison sentence are those which use weapons and are quite violent and high value. So it doesn't mean to say that somebody with a simple robbery will get life imprisonment. This is a maximum. Now this is outlined in Section 8, Subsection 2 of the Theft Act of 1968. And don't forget, when you're doing problem questions, we need to always mention what the possible outcomes of the case might be. Okay, thanks for watching.